Peace to the gods, peace to the gods. Let me get a mic check real quick. Man, what is all of this? All right, y'all, I'm here. I'm just trying to get some stuff. I'm about to show y'all some. I guess I'll just do it like this then. Peace to the gods, peace to the guy. Everybody doing tonight? Everybody doing tonight? Doing okay? I was trying to what I need. I need that right there. I can't even log into my damn website. What's going on, man? It's crazy. All right, hold on, y'all. I got it. Just give me a second, real quick. We're doing two things tonight. First, we are going to continue our delve into the Clerks Praxis to get some understanding in that. But what I'm going to do prior to that is I'm going to show you how to put together an affidavit of truth. Somebody called me and they wanted to know. They called me and said, I want to put together an affidavit of truth. So I told them I was going to go ahead and I'm going to start out today's broadcast showing you how to put together an affidavit of truth. And what I'm going to do is if you're new, I'm going to show you how to pull pieces from disparate sources and construct your own affidavit of truth based off of pulling things from different areas. All right, because you may not be able to think up the wording for yourself. A lot of people do this. A lot of people, I'll say 90% of the people in this space do what I'm about to show you right now. All right, very few people write their own stuff off the top of their head. And when I see something, it's usually something from something else or some other person put together or something like that. So just to start off, it's cool to do that, when you're starting off. What is this? Okay, hold on. Oops. The hell? this right here. This right. Took me all around the world just to dang log in. I'm like, dang. My website is kind of like, yeah, you're like, damn, I'm trying to log in and see what everybody be talking about. All right. So I'm logged in. So let me see. First of all, let me do, how's everybody doing tonight? Let me pull this out. Mom took the kid overseas. Idea how to get the child home. Nope, that's a completely different jurisdiction. What do you want me to do? What do you want me to tell you to do? Well, go watch that movie. Our boy went over that. That's a private matter. That is strictly a private matter. If you can't hire like a private detective, somebody to go get them, you got to take matters in your own hands. Or that, unless you can talk to the government over there or something like that. But, you know, I'm going to tell you something, man. Women take children when you really want to see your children. When you don't want to see your children, they do everything they can to throw the children on you. Sometimes, you know, you may have to use a Jedi mind trick to get what you want. You know, have you noticed that? All the men that want to see their children, they've taken from them, and all the ones that trying to get ghosts, say, why you ain't seeing your child? You know what I'm saying? It's like, I don't know what that is. What's going on, T. Williams? What's going on, T. Williams? So, I don't know what to tell you on that, but let's get to today's lesson. All right, so the first thing we're going to do is we're going to put together an affidavit. So I'm going to be pulling this from about 3 different sources just off the top of my head. The books are going to be Cracking the Code, the 3rd edition. All right, I'm going to be using Cracking the Code, 3rd edition. I'm going to use that as my outline for my affidavit. I'm going to use abatement at common law. I'm going to pull some stuff from there. And I'm going to pull some stuff from the affidavit of truth. The affidavit of truth. So I'm going to use 3 different pieces of paper. And what I'm going to do, I'm going to pull stuff. And as I pull stuff from these different documents, I'm going to construct an entirely new document. Also, I'm going to explain what every portion of it means as well, okay? So, somebody say, why would you want to, why do you think you have to record something? You put affidavit into evidence of court. What are you talking about? What are you talking about? You're talking about you recorded. What be on y'all mind? Y'all be thinking y'all got to record stuff in the real estate records? You're going to need an affidavit if you go to court. What do you think? Where do you think they put affidavits at? What are you talking about? Why would you need an affidavit? You need facts on the record. Oh my goodness gracious! Y'all need to stop. Y'all need to start studying law and stop following these fringe ass. There is such a thing as a sovereign citizen. I'm gonna start calling it out. I'm gonna say that is a sovereign citizen. We're gonna start playing that game. Somebody gonna ask a question, and I'm gonna say that's a sovereign citizen question. Or I'm gonna say that's a private American question, or I say that's an intelligent question. I'm not gonna cuss you out. I'm just gonna say that's a sovereign citizen right there. And they line of thinking. Because I am beginning to see how these people think. I'm like, why would you need an affidavit? How is you going to introduce evidence into the record? You only introduce evidence through affidavits, sworn testimony, depositions, notarized documents. How you going to win? You ain't got no facts on record. He thinking about recording it down in the real estate records or some shit like that. That's that sovereign citizenship. I believe that's that sovereign citizenship, doing things like that. Where are we going to record it? Who are we going to give a notice to? You need an affidavit on the record. Thank you, Rick Sounds. I appreciate that. I appreciate everybody donating. Peace, God. See you Saturday. I'll see y'all once again. If you ain't got your tickets, get your tickets now. $3.99. You can bring somebody with you, okay? And it's going to be in Dallas, Texas this Saturday and Sunday. Be there on Friday. Come in Love Field Airport. Don't come in at DFW because your ass is going to be traveling a long way. You come in at Love Field, you can take an Uber and be there in about 5 minutes, okay? So, Love Field Airport, remember that. It's a nicer airport too. I like Love Field. I love Love Field. Love Field is a nice airport. All right, so let's get to this, man. Hold on. Let me get to this. All right, so let me see where I'm gonna find these documents at. Let me pull them up first. All right, so we in the back of SPC University. And as you can see, this is all the records. Okay, so you see affidavits, right? Let me see if something in here. Let's see, affidavit. Yeah, I think this is one right here. Yeah, I'll use that. I'll use that. Let's see. I'm gonna put this documents. I'll use that one real quick, and I'm gonna use. Oops. I'm gonna use a document. We're on SPC University. I'm gonna use a document called. I think I got it in here. Let me see if I got. I don't know if it's in here. Hold on, let me see. I probably didn't upload it yet. Let me see. No, I did upload that. That's in here. All right, hold on. Let me go on my files. And I'm gonna use another document called Abatement at Common Law. And I'm gonna use a program. There's a program out there called Abby Fine Reader. It's called Abby Fine Reader. You need to get that. That is a badass program. It converts PDF documents to Word documents. So that is definitely a time saver. It's called Abby Fine Reader, and I'm gonna show you that too in just a second. But let me go to my Dropbox real quick. What is this for, boy? You know, I'm probably had to do this at the end of it, man. This is a new computer, and it's just like everything. They got so much security on stuff now. It's just this shit is just like annoying as hell. It's like verify your account, verify your account, verify your account. I'm like, dang, what do you know? What is this? You know what I'm saying? Then they throw me a 6-digit code. I got to pull a code out my email and everything, and it's like this shit is just like they got to find a better way. And this is some annoying ass shit. This is no annoying as hell. All this right here. This shit is crazy. Oh my God. Forget it. I'm gonna do something else. All right. Let me do it like this. Cause this is just too crazy. Me trying to do all this right here. It's like, dang, I had to go through all of this just to log in. It's crazy. It's like, what? It's ridiculous. All right, so let me do it. Let me just do it another way. And let me put a word real quick. Y'all just bear with me. I know I put word on here. This is incredible what this thing is doing. I can't believe all this is happening right now. And we'll come back to this. Let's get back to Clerks Praxis. I'll do the affidavit. Let me do Clerks Praxis first, and then we'll get back to the affidavit because this is just like ridiculous. So let's get back on point. All right. Let me get back to cracking. Let's get back to the affidavit. Back to the Clerks Praxis. Now, last week we were studying the Clerks Praxis, and I'm going to give you a recap of what we talked about last week. The Clerks Praxis, what we're discussing is the jurisdiction modern courts are operating under. And whether or not it is, like if you get in a criminal case, what is the true nature of the case? The Sixth Amendment for the Constitution of the United States of America protects your right to know the nature and cause of any action that is brought before you. All government officials have sworn an oath to uphold the Constitution. We do have a representative government. That means they are selected from us, and they are supposed to represent our interests, and they are supposed to honor and uphold the Constitution for the United States of America. The Constitution of the United States of America is what grants them their power, and the Constitution of the United States of America restricts their power. You are really not a party to the Constitution for the United States of America. Private citizens, because the Constitution doesn't give you any rights. The Constitution protects your rights. Your rights are given to you by the creator of the boundless universe. In a Republican form of government, in the Republic, we are supposed to be exercising those rights. In a democracy that they like to talk about so much, that's not listed anywhere in the Constitution, the Declaration of Independence, you don't swear that when the Pledge of Allegiance when you was in elementary school, none of that. Did you swear to uphold any democracy? You swore to uphold a Republican form of government, and it is time that you understand what that is as a private American citizen. Now, this also affects your ability when you go into court in order to exercise your rights or access your rights. But before we can get into putting in affidavits, before we can get into having a discussion about what your rights are and how to enforce your rights and how to discharge a debt and how to discharge a criminal case and how do I handle myself in a criminal case and how I get my kids back from overseas and stuff like this, all this stuff y'all like to talk about, the first thing you got to understand is you got to understand what you're dealing with. And if you don't understand what you're dealing with, I don't understand how you can even fathom to begin to understand how you're going to reach some sort of like what everybody like to say remedy. They'll say remedy. Remedy means right. Let's look up the word remedy real quick. Let's look up that word real quick because people like to use that word. You hear that word? What's my remedy? What is my remedy? Does Yusef have remedy? Can he get remedy for us? Can he get remedy? He don't have remedy. You have to come over here and get remedy. I mean, they use that shit like a slang on the street. Just be talking. I'll be listening. I said, do you even know what that word means? Do you know what the word remedy means? How many people looked up the word remedy? All right, let's look it up real quick. Because when you're over here, you can't say that you don't know what the word is anymore. So let's look it up. Let's look it up. Because they like to use that word a lot. Remedy. Where is my remedy? Help me locate my remedy. They use these words a lot. Like cesticate trust. They'll use that word a lot too. Remedy. All right, let's see what remedy means. Remedy. Here it is right here. Remedy. Sense one. The means of enforcing a right or preventing or redressing a wrong, legal or equitable relief. Remedy, a term civil. Remedy, release, also termed in both senses law of remedy. A remedy is anything a court can do for a litigant who has been wronged or is about to be wronged. The two most common remedies are judgments that plaintiffs are entitled to collect sums of money from defendants and orders to defendants to refrain from their wrongful conduct or to undo its consequences. The court decides whether the litigant has been wronged under the substantive law. It conducts its inquiry in accordance with the procedural law. The law of remedies falls somewhere between substance and procedure, distinct from both but overlapping with both. And you know, equity goes to substance and the legal goes to, you know, procedure or form, into form. All right, so now you understand what a remedy is. All right, now, to get your remedy, you got to know what you're dealing with, what kind of court that you're dealing with. Because there's a different type of remedy in a commercial court as opposed to a common law court, as opposed to a court of an admiralty or equity court, things of that nature. You got different jurisdictions. All right, so the thing that is everybody is curious and wondering about is what kind of court are you going into when you go to a U.S. district court? What kind of court are you going into when you go to your superior court there in your local county, your county court? What kind of court are you in? What kind of court is a state court? What kind of court is a misdemeanor court? What kind of court is a superior court? What kind of court is the Supreme Court of the state of Georgia? What kind of courts are we dealing with? And what is the difference between an Article I court and an Article III court? And what kind of remedies or rights do we have in each one of these? I remember reading a paper, and I got to go do some more research on this. The Supreme Court justice said that people living in Washington, D.C. don't have no right to be in an Article III court, which I can agree with because D.C. is a territorial jurisdiction. So I kind of jive with what they're saying, but I don't think that means they can't change it. I don't think that means they can't change it. So all right, so let's look at the Clerks Praxis. So the Clerks Praxis, let me give you some background on that. The Clerks Praxis, I came into the Clerks Praxis, the knowledge of it, I was reading Gene Keating's transcript, and I was in jail. And it was the best, that was a very good read. If you're in jail or you're trying to get yourself out of jail or you're dealing with any kind of matter that is dealing with some sort of the criminal justice system, two documents you must read is the Gene Keating transcript and the Gene Keating prison treaties. The prison treaties goes into the who owns the private prison system, how they are located on the stock market, and how judgments are being sold and who they're being sold to. He did a lot of research into that. That is some very important information. The Gene Keating transcript introduces you into the GSA bonds, the Standard Form 24, 25, and 25A, the Miller Act bonds, 273, 274, and 275, Affidavit of Identity, Standard Form 28. All of these different documents, as well as the Clerks Praxis. This document, when he introduced this to me, after reading it, it gave me a fresh set of eyes when I started reading statutes, okay? Because you understand the statutes, the principles of law are being used in the public and the private. They're being used on both sides. So I understood that the statutes had to be pulling from somewhere, and also Howard Freeman, he is the one that alerted me to the fact that the UCC connection, in there he was talking about how, that judge said that they were told that they could call their jurisdiction whatever they wanted to call it. They couldn't call it admiralty. So in order to understand how they are hiding the admiralty, you got to go and study admiralty. And then once you study admiralty, you can go and look into the statutes and say, look, they call this creditor and debtor law, but it's really the same thing as what's in this Clerks Praxis. You'll be able to see it. Okay, I hope everybody's following me. Okay, so Let's get back. So on the last week, we were reading the Clerks Praxis. Let me put this on me. The Clerks Praxis is broken up into 3 parts. The first part is the history, which is very important. It's very interesting to read the history because, you have a lot of people talk about common law courts as if the admiralty courts are evil and the common law courts are good. That's how people talk. Like the common law courts are the good guys and the admiralty. But when you start studying this, you're like, nah, the common law courts are really rough. And, that's why they came up with equity to kind of temper the rigidity of the common law. The common law was harsh. It was very, very harsh. The admiralty was more concerned with making money. Well, they all wanted to make money. I ain't gonna lie. The church wanted to make money. The admiralty courts wanted to make money. And the common law courts wanted to make money. That's why they were vying for power with each other, okay? The whole underlying thing of why these courts were vying with each other and battling with each other is because of money, all right? Because whoever has the court's making money. You see it today. People are making money with owning a court. You would really behoove you, too, to watch a video on YouTube. It's called The Judges, the Judges Slush Fund. As a matter of fact, let me pull it up on the screen so you can see what I'm talking about. It's called Judges Slush Fund. And this video right here is a part 1 and part 2. And I actually had her as a guest on my show. And this individual, Dr. Shirley Moore, that's her name. She was on my show. This was about Child Protective Services. A lot of people are always asking me about Child Protective Services. She did some research into it. She found out that, like Child Protective Services was stealing children from individuals. They were using x-rays, like they show an x-ray of the child with a broken bone, but they were using that same x-ray on a lot of different cases. And, saying that, the person had hurt the child. And she uncovered a lot of things, but the biggest thing that she uncovered was who owns the court system. She did a Freedom of Information Act and was able to obtain their EIN number and found out that these courts are privately owned. They're privately owned trading companies. And she got the evidence. Now, this lady didn't have anything to do with any type of sovereign citizen movement or anything like that. She was just a lady that was concerned with Child Protective Services. I'm really in awe at how many people have not even watched this and studied this. What this lady was showing everybody is so important for people to know. If you want to talk about Child Protective Services and all that, then like I said, you need to know the nature of what's going on. And this right here showed you a lot of what is going on. This right here. Also, there was a senator. She's from Ohio. Let's see, what's her name? I think it's Nancy Schaefer.
Our next speaker is Senator Nancy Schaefer.
Okay, this lady right here, she ended up dead. She was informing everybody that Child Protective Services was kidnapping people and human trafficking people, and she ended up dead, her and her husband, I believe. And it's just amazing to me this is what's amazing to me about how we get down. I could show y'all that somebody will come and ask me a question about Child Protective Services, which I don't have a problem with Child Protective Services. But if you do, why wouldn't you start studying and get on the trail of what this lady was doing and find out what's going on? And also what Dr. Shirley Moore was telling you. I'll show people that, and they'll just gloss right over it and not even pay any attention to it. If you're having problems with CPS, why would you come and ask me a question? And I just told you these people that did way more research than I've done on Child Protective Services. Why, when you go and start, I'm doing other things. I don't have time to investigate Child Protective Services. But if you got a problem with them, this is what you should be on. You should be carrying the torch for these people right here and find out, okay, well, what is it they didn't want you to know about Child Protective Services? You need to understand that. Okay, your children come up, it's 300, how many children? Something like 600,000 children a year come up missing or something like that. I forgot the number. You know, all you have to do is look at your Amber Alert. It's always a child coming up missing. Ain't you paying attention to what's going on? You see the human trafficking that's going on. They talking about Andrew. Somebody come on my show talking about Andrew Tate, but they you don't want to talk about Jeffrey Epstein and Epstein Island or anything like that. You talking about Andrew Tate? Are you serious? Are you serious? You can't be serious. You can't be serious. What's up with the commercials popping up? It's called Me Getting Paid. That's what's up with it. What's up with the donation? Hold on. Did Jody Stickamoo donate? You ask me what's up with a commercial and you ain't put no donation in there. Ain't no donation. Why would you ask me a question like that? You should say, look, I'm donating on, if you donated on the channel, I wouldn't run no commercials during it. If you donated, but it's like, hey, you monetize. It's called monetization. It's like when you watch television and you have commercials with TV, it's the same kind of thing. I'm getting paid by my sponsors or whatever, But anyway, all right, so I think that's enough of a little history, okay? So yesterday or last week, we were about at the part where they were talking about the barons had their courts. And I think, I don't know if the rest of this is going to be that interesting. Offenses against the Admiral, the Navy, and discipline of the sea. Contract. This is the complaint. This right here, like some complaints they put in. Resolution upon cases of the Admiralty. And I don't know if this might be a little bit too high for the jurisdiction of the Court of Admiralty settled. The Lord of Commons assembled in Parliament, finding many inconveniences daily. Because all this right here that I'm reading right here, let me put this back on the screen. This right here is like complaints. Okay, remember I was telling you how the common law courts and the Admiralty courts were warring with each other, and they had to get a resolution, and they brought a complaint of on that, offenses against the public, and this is the complaint right here. Heads of the article of inquisition taken at Queensborough in the year 1376 and the 49th of King Edward III by 18 expert seamen before William Neville, Admiral of the North, Philip Cortency, Admiral of the West, and the Lord Latimer, Warden of the Cinque ports. Offenses against the king and the kingdom. Number one, of such as did furnish the enemy with victuals and ammunition, and of such. And, this is right here, a lot of Admiralty stuff. And I don't really want to get into that. This is their complaint, and, they complaint, and then they had a resolution. These are the people that brought the complaint right here. I don't think this is going to be very interesting to read. And this right here, they talking about what they talk, if suits should be commenced in the Court of Admiralty upon contracts made or other things personal done beyond the seas or upon the sea, no prohibition is to be awarded. That should be of interest also. But let me show y'all this real quick. Real quick. All right. This document right here, it kind of goes hand in hand with, it's called the Secret Maritime Jurisdiction Exposed. This is probably the baddest document I ever read on Admiralty, all right, of modern research. It was done by Valiant Liberty. And this is all very interesting. The accusation, maritime causes. I mean, this is what I want to read. I want to read this because right here, when you read this, they got the case law. And let me show you the case law. Let me pull this up. Let's see. What many victims accused of maritime crimes don't realize is that the admiralty and maritime jurisdictions were merged with the law and equity jurisdictions in 1966, Federal Rule of Civil Procedure. All four causes of action or nature of the cause, which were once separate and distinct, are now rolled into one set of rules and indistinguishable from one another in our modern courts. Federal Rules of Civil Procedure, Rule 1, that provides these rules govern the procedure in the United States District Court in all suits of a civil nature, whether cognizable as cases at law or in equity or in admiralty, with the exception stated in Rule 81. Rule 2 provides that there should be one form of action known as a civil action. All right, provides that in part, if the claimant cognizable only in admiralty, it is an admiralty or maritime claim for the purpose whether so not identified or not. So they don't have to identify it or not. It's an admiralty claim whether they say so or not. These rules should not be construed to create a right to a trial by jury of the issues in an admiralty or maritime claim within the meaning. They said, well, now aren't the rules revealing? Maybe this explains why the judge can amend or reverse a jury verdict or even jail the jurors for contempt if they do not do what the judge tells them to do. It has happened. The jury is just there for window dressing to make the sheep think that there is a trial by jury. And that's true. That's what we say, that it is all just a dog and pony show. That's what I try to tell people, that going to trial, man, it's a stage play. That's why I tell you to read the Clerks, creditors and their bonds, because he explains that in there. It's all a stage play. They got that. That's why they got a 99% conviction rate. 99%. They say it's like 98, but I ain't never really met nobody that won too much. They say, there's 2% of the people win or something, 1%, but I ain't never met them. Not like in a jury trial. Not in a jury trial. So right here, if the criminal accusations that plague Americans today are not in the jurisdiction of common law or equity, they must be in admiralty or maritime jurisdictions. And though admiralty and maritime jurisdictions are virtually indistinguishable, Bouvier's definition of a maritime cause as those arising from maritime contracts, whether made at sea or on land, fits the bill. Okay? And so right here, let's keep going. For the sake of illustration, let's take time to consider the condition of military personnel. When a young man enlists in the armed forces, he signs an enlistment contract that binds him to the law of the Code of Military Justice. This Code of Military Justice cannot apply to civilian folks who are not contracted. Under the Code of Military Justice, the accused is guilty until proven innocent. If the accused wishes to defend himself, he is put into the position of trying to prove a negative, a virtual impossibility. Namely, he is put into the position of proving that he did not do something. The military court or court-martial, where these military cases are tried, is a legislative criminal court established under the legislative power of the Congress to regulate the armed forces. Their jurisdiction is entirely penal. An action upon a penal statute is defined as an action for the recovery of a penalty given by statute. Remember I told you about penal actions yesterday, how they civil in nature? We read that on the last video. The jurisdiction is entirely penal, and the action upon a penal statute is defined as an action for the recovery of a penalty given by statute. Also, just to kind of case in point, I don't have it on me, but I was in the law library here in Georgia, and I was studying child support. And you know how people say that you can't be put in jail for a debt, but the Attorney General, there was Attorney General opinion says that you can be put in jail for a debt for a penal code violation. They said for a penal code violation, you can be put in jail for a debt. Now, that was interesting. And I just ran across that. It's amazing when you go into the law library and you just got to put your heads in the book, all the things you'll run across. You just run across so much stuff like, wow, I didn't know this. But that was really interesting about child support. And I also ran across the fact that child support is a debt collection. They are debt collectors. They are debt collectors. All right? So, right here, the military court or court-martial where their military cases are tried is, okay, I already read that. The jurisdiction, we right here. The jurisdiction is entirely penal. An action upon a penal statute is defined as an action for the recovery of a penalty given by statute. In a broad sense, the term has been made to include all actions in which there may be a recovery of exemplary or vindictive damages. An action in which the judgment against the defendant is in the nature of a fine or intended as a punishment, or intended as a punishment. And disciplinary. The word penal is inherently a much broader term than criminal, since it pertains to any punishment or penalty and relates to acts which are not necessarily delineated as criminal. Military personnel are subject to court-martial penalties because they are under a maritime contract. All right, and it goes on. Did you ever notice that Texas has a code of criminal procedure but not a criminal law? That's right. There is no criminal code and not one criminal law in Texas, but there is a penal code that is just chock full of offenses. Let me put this on you. That's another thing about these different states. Some states like Georgia, they'll be very transparent about things. You know, you read creditors and their bonds, you come back and read OCGA 1711.1, OCGA 1711.4, and things like that, and you see evidence of this being true. The same thing with Texas. Texas don't have, like he just said, they have a penal code. They don't have a criminal code. It's penal code, so when you start studying this, you see it's civil in nature. They call it criminal. And that's why you got to study, for the sake of reminding you, because I know we got some new people on here, let's look at the definition of a penal action real quick. Let's go in our dictionary. And we'll go back to Black's. We're going to go to the 8th edition. And we're going to look up action. And then I'm going to search out Control F, penal action. Let's see if I can. All right, penal action, the recovery goods taken by force. It appears 9 times. So let's see. Penal action. So, all right, let's read this very carefully, all right? Let's read this very carefully. All right. Penal action, a criminal prosecution, sense 2, a civil proceeding in which either the state or a common informer sues to recover a penalty from a defendant who has violated a statute. Although civil in nature, a penal action resembles a criminal proceeding because the result of a successful action is a monetary penalty intended like a fine to punish the defender. Now, after reading that, let's go over here in Georgia, and I'm going to show you what these state statutes kind of reveal. So if you go over here to OCGA 1711.1, so this is imposition of cost of prosecution on the defendant generally. This is a general imposition. It's just general information. The cost of a prosecution, the cost, this word right here is important for you to know. Cost, it doesn't mean what you think it means, of a prosecution, except the fees of his own witness, should not be demanded of a defendant until after trial and conviction. If convicted, judgment may. Now, when you pull this off the shelf, this means must. It does not mean they have an option. I'm going to show you that if I can. The judgment may be entered against the defendant for all costs accruing in the committing and trial courts and by any officer pending the prosecution. The judgment shall be a lien. A lien. Look what we're talking about. We're talking about a lien. This is criminal procedure. This is a criminal procedure. So when you found guilty, they put what? The judgment shall be a lien from the date of his arrest on all the property. What property are they talking about? What property? What if I'm a drunk off the street? What? I don't own anything. You still have a social security number. You still have a social security number. All property of the defendant, the clerk shall issue an execution on the judgment against the property. What property? This is what they talking about, the GSA bonds. The property, where is the property located? See, when you read these state statutes, you see evidence of it. They talking about, well, this ain't no debt collection. Well, hell, how you put a lien is evidence of a debt, man. If you're an attorney looking at this, in all criminal prosecutions, if I'm found guilty, you putting a lien against me? This is why they don't want you to file a UCC-1. This is why we're filing a UCC-1, and this is why you're bringing your UCC-1 into court and filing it to let them know you already got a priority interest against your property. Let's look at another one. Let's look at another state statute that revealed some stuff. Let's look at another one real quick. Let's go down to Louisiana. somebody was doing some research and they found this in Louisiana. Criminal procedure, once again. Corporate existence presumed unless an affidavit of denial filed before trial. On trial of any criminal case, it should not be necessary to prove the incorporation of any corporation mentioned in the indictment unless the defendant, before entering such trial, shall have filed an affidavit specifically denying the existence of such corporation. This is in all the 50 states, but when you read these different state statutes, somebody slips up in every state and gives you a piece of the puzzle so you can see. In every state, somebody gonna slip up and throw your piece here, throw your bone here. This is why we put an affidavit of non-corporate existence. This is why you have an affidavit of non-corporate existence. What is an affidavit of non-corporate existence? Let's look at it real quick. What is an affidavit of non? We can go into abatement at common law. And right here, we got one. Affidavit of denial of corporation existence of your name. 1. Yusef, the live man, and state of Texas, exempt hereinafter of fine, declares and states that the following facts are true to the best of my knowledge and belief, and of which one has first knowledge of the matters stated herein. 1. Yusef is the age of majority and competent to testify of the matters stated herein. If any man or woman desires to answer this affidavit, please do so in the manner of this instrument by notarized affidavit using your Christian or family name for signature and mailed to the below named notary address, provided within 5 days, or default will be obtained. Your handwritten signature only. Do not type it out. That's what they like to do. They like to type out the name and to avoid liability. Y'all get documents all the time in the mail, ain't signed by nobody. You get all scared and shit like that. You get a letter in the mail, and you just look at it, ain't nobody got this computerized document. They just shot something at you just to scare you up. You send it back, say, look, didn't nobody sign this. Who taking liability for this? I need somebody with the ability to bind your corporation, to sign this in a wet blue ink signature and send it back, because I need to know whose head I need to chop off. Who is accepting liability? So right here, a fine hereby denies that the following corporations exist and their capacity to sue or be sued is challenged by negative averment. This is a negative averment. It said, okay, y'all got to prove it. The burden of proof is on you, all right? United States, aka United States of America, the state of Texas, county of whatever, name city, all bar associations, United States District Court, and then your name in all caps of the address and put your name. All other corporate members who are or may be associated with any complaints against my natural body. 1. Yusef has no contract with the state or federal governments, which give equity jurisdiction to the courts. 1 has no bank accounts or no credit cards. That right there, you don't put it in your social security number. Because that's a what? Minimum contact. Pay attention. This thing is very educational. This is written by a Juris Doctorate, okay? So you don't have no bank accounts or no credit cards and what? It ain't saying you can't have them. You can have them in that business name. Don't have them in your social security number. 1 has rescinded the government's social security number. Look at the very next sentence. And any present or future benefits of that socialist system for religious conviction. 1. Yusef has signed no international maritime agreement with the state of so-and-so or federal government, either intentionally, willingly, or knowingly, which would give admiralty or vice admiralty jurisdiction to the courts of either the state or federal government, and does not voluntarily submit to any of those jurisdictions. 1. Yusef is subject only to the common law of the Republic State of Georgia or Texas, and the United States of America, and is not subject to any corporation or a system of administrative law. Remember what I was showing y'all last week about administrative law? When you go and get American jurisprudence and study administrative law, and administrative law is only, let's read this real quick. Let's read this. This is what you have to do. I'm doing exactly what I used to do when I was in jail. I'm going back and forth, showing y'all exactly what I was doing. All right, so I had to go back and had to look right here, and I had to go to my library, my PDF library over here. and I had to pull out an American jurisprudence. I had to say, okay, what is administrative law? We're not going to read much of it. We don't have to. We can read the first couple of paragraphs and tell us a lot of stuff we need to know. So American jurisprudence, I got a lot of them right here, as you can see. All right, so let's look at, oh no, this is the wrong thing. I'm looking at Clerks, Praxis. Where is it at? Wait, hold on. Yeah, let me go back. Okay, I'm sorry. Hold on. Yeah, let me go back again. We on SBC University. And here's American jurisprudence right here. So if you're a member on this site, there it goes right there. And let's look down here and let's find oh, there it is, administrative law. Okay, let's read and see what they say about administrative law. What do we need to know about this administrative law? What do we need to know? What are they going to show us in this book? I mean, this was a very interesting book. I sat back and read all of this. I mean, they just gave me all the time in the world to study this so I could come out and show it to y'all. All right. So last week we were talking about administrative law. And I think that's the footnotes. See right here, concern with private, right here, private and public rights. All right, so let me go back. It says, the term administrative law, while well recognized by judicial and other authorities, has no authoritative definition. Administrative law is concerned with the legal problems arising out of the existence of agencies which combine in a single entity legislative, executive, and judicial powers. That's what your United States corporation is. It's a legislative entity that is combined executive, legislative, and judicial powers under one. These are powers, okay? Not branches of government. It's just like powers like you have when you at home. In your house, you the legislature. Kids, you're going to have your ass in the house at 10 o'clock, all right? You make the laws, all right? You enforce the laws. Somebody's getting their ass whooping today. And then you adjudicate the laws. Your ass is on punishment for the next week. Now, you ain't no damn cell phone, no damn PlayStation. All right, that's what they do to you. When you come into their house, into their jurisdiction, they mama and daddy. They making all the rules for you because you in their house. And you can't go tell nobody. You call the police if you want to. Man, I can't even understand y'all parents today. Man, if I would have said when I was growing up that I was going to call the police on my mama would have called the police and said, come get this motherfucker. After she bandaged me up, I'd be bandaged up, and then she'd call him and tell him to come get me. Then the police would have did it. Wasn't nothing happened to her either. I can't even understand what's going on today. This is just, do y'all be watching this? This is just incredible. I'm looking at it like, wow. Wow. It gets on, it says, all right, so it says, generally speaking, administrative law deals with officers and agencies exercising delegated powers and not with the exercise of constitutional powers of the executive. However, the chief executive as well as other executive officers may be made a delegate of powers by the legislature, and exercise of such powers by the president or governor is within the scope of administrative law, and judges. Judges fall under that too. But let's read this right here. This is the big one right here. Concern with private and public rights. Sometimes the language of private rights is used in the administrative context. It's used in the administrative context because private, because when you come into their jurisdiction, it's like a special jurisdiction or private jurisdiction. Remember, they have plenary power within their jurisdiction. It does not fall under constitutional restrictions when you come in a territorial court. So it's private in nature. That's why they call them private courts. So it's private rights is used in the administrative context. However, the language may simply signify a policy relevant to administrative law encompassing both public and private rights. Because administrative agencies serve in part to effectuate the constitutional obligation of the executive branch to see that the laws are faithfully executed, the public interest is an added dimension in every administrative proceeding. Whose interests are they concerned with? The public interest. In addition, the public rights doctrine, okay, I had to go study that when I studied public rights doctrine. Write that word down. You need to be reading it, write that down, add it to your vocabulary. Impacts administrative agencies. In certain areas, the principle applies that particular administrative agencies are created to protect the public interest and not vindicate private rights. I took this right here and put it in my affidavit. I said, y'all are only concerned with protecting the public interest, not the vindication of private rights. So when I see something like that, I add this in here. I did it, and I said, okay, the principle applies, that right there. So I'm going to add that in my affidavit. I'm going to say, okay, y'all only concerned with the protection of the public interest, not my private rights. So they're not in your administrative law court. They are not concerned. They are not there to vindicate your private rights. So now it's very important for us to know what kind of court we are in, okay? So let's get back to this right here. So right here, what did I say? I said what? I said what? I said one Yusef is not subject to the common law of the Republic State of Georgia and the United States of America and is not subject to the corporation or its system of administrative law. One Yusef is not a corporation because what? They only concerned with the public. They're not concerned with your private rights. So what you put me under administrative law for? And administrative agencies were only originally there for corporations. He's going to explain this too. One Yusef is not a corporation or member of a corporation, a trustee or beneficiary of any trust created by government, is not a legal fiction or juristic personality, and refutes any unknown nexus which might attach him to any such entity or jurisdiction. One Yusef cannot be held in involuntary servitude or peonage pursuant to the 13th Amendment to the United States Constitution. I'm not voluntarily going nowhere. See, when y'all sign all them paperwork, y'all voluntarily submitting. I'm not voluntarily submitting to be a slave. Yes, I know Louisiana operates under the Napoleonic Code. It was a French colony. One Yusef has never applied for bankruptcy and never given his permission to the state or federal governments for his participation in any bankruptcy scheme of the federal or state government or the Federal Reserve Bank Incorporated. What is he talking about right there? A bankruptcy scheme. He's talking about this right here. He's talking about this right here. He said, I'm not a party to this. This is not your debt. This is not your debt. Oh, here it is right here. That's not your debt. That's the U.S. debt clock. That's their debt. They're making you party to that debt by a social security number because you wasn't got a job. And they're taking money out of your check to pay back the national debt. So you're a party to the debt by way of social security number. So you're a slave worker. You see what that says? That don't say United States of America, that says U.S. debt. Like U.S. courthouse, like U.S. postal service, like U.S. citizen, like U.S. person. Wake up! You can teach this to fifth graders. All right, so let's keep going. What was I'm looking for? Okay. All right, so we just got through reading that. Let me go back to right here. All right. Okay, one Yusef is a live natural man living upon the soil of the sovereign Republic of Texas. One Yusef is not subject to the federal law legislated, we're talking about legislature again, by Congress under its authority of Article 4 of the Constitution of the United States or state or federal admiralty, equity, jurisdiction, judicial jurisdiction. One Yusef is subject only to the law legislated by Congress under its authority of Article 1 of the Constitution for the United States if the law is complied with the Paperwork Reduction Act, the Administrative Procedures Act, and the Federal Registry Act, which would specifically identify the law as being applicable to the general population of the 50 states of the Union of States of America. One Yusef is subject only to a Republican form of government pursuant to the national Constitution and the Constitution of Texas under the equal footing doctrine of the Constitution for the United States of America, not under a corporate municipal form or quasi-military form of government known either as a democracy or martial rule. Further, fine said not. Now, you could just copy this right here and put it in any court case. And I just see right here, you just see right here in Louisiana, they say they have the right, we at least know in Louisiana, they have a right to presume you are a corporation unless you do what? Put in a affidavit of denial of corporate existence. Why do you have to do that in a criminal procedure? Let me turn the camera. What? This is how See, y'all lucky y'all got somebody like me, all right, who got years of doing this and have accumulated. That's why I got a university, because I done accumulated all of this stuff over time. Now, does that apply? The next question would be, does this apply to other states? Well, it may not be specifically listed in other states, but you can best believe that they unified with this all over, because that's why they all got all caps names, your name in all caps. And even if it isn't, wouldn't it be prudent to put it in anyway just to cover your bases? See, that's why I show you stuff like this, because he's like, well, does that apply in Detroit or in Michigan or in Texas? I don't know, maybe, maybe not. But I know this, I'm going to put it in just in case. Doesn't that make sense? Because that's a question that somebody will ask. But one thing I will tell you is they all follow the same principles. They all are bankrupt. Everybody's using Federal Reserve notes in all 50 states. They are all operating under color of law. Why wouldn't this apply in all 50 states? Why are they all unified and putting your name in all caps on all your utility bills, on all your court pleading documents? They try to tell you it don't mean nothing. They say, well, that don't mean anything. Oh, it doesn't. It doesn't. Corporations used to be listed in all caps. Why are we seeing all this stuff? Why is it Yusef? Why you keep talking about secured party, Yusef? I'm showing you why. I'm showing you why, all right? There's a lot of shit I can show you. It ain't like, y'all, I think some of these dudes, some of my detractors, y'all think I just pulled this shit out of my ass and I just found a quick way to make money. That's what the impression y'all like to give on people and everything. Fuck the fact that you've been reading all this shit for the last 15 years, Yusef. We don't give a fuck about none of that shit. I can show you what I'm talking about. Using their statue. That's why I'm using their stuff. Because I don't like to hear that sovereign citizen talk. So to alleviate that, use their stuff. Study principles of law, understand jurisdictions, study admiralty, come back and read their shit and break it down. They talk shit because they know the average person is lazy, ain't gonna do it. And then half of them that's talking shit in the public, they don't know either. The clerk don't know. 80% of the attorneys don't know. Probably 50% of the judges don't know. You be giving them too much credit. A lot of them are innocent. They don't know. He's an administrator. He does what the fuck he's told. You giving them too much credit. That's another mistake you make. You give them too much credit. You give them too much credit. All right, so right here, this was a nice little affidavit. This is a nice little affidavit. Now, I'm going to read this. Here's something else you can use. There's something else you can use. This right here is a letter to the judge right here. This is a badass letter. This is the baddest ass letter I have ever read. You can use this in any case, in any case, in any case. You don't want to walk in and surprise the judge. I want to thank you, BMG Trust 3, for the Bone 99, brother. I appreciate it. I appreciate it. All right. Right here, this letter right here is badass. This is a letter you can send ex parte, because it's not doing anything with the judge. It's just a notice to the judge, because you're trying to give him a heads up of what you come in, because you don't want to sideswipe the judge. You don't want to do it, Now, look, be warned. Okay, a gentleman always gives notice, because you got to understand you don't want to alert the public. So you come in there and you start talking all this shit, and he catch him off guard. He got to act a certain way. So give them a heads up. But sometimes when you give them a heads up, they got to understand they're going to be ready for you. They're going to be ready for you. But you should give them a heads up. Look, man, this time I'm coming into the court, man. I'm not average. Letting you know I got some special knowledge, and I'm coming in here. And this is how I'm coming in. So let's look at what we're going to tell the judge. The Honorable Judge so-and-so. When I specially visit your court on a forced response on such and such date to a bill of pains and penalties. Stop for a second. What is a damn bill of pains and penalties? This is a very interesting word. Let's look it up. Let's look it up. Let's look it up. This is a damn interesting word right here. Bill of pains and penalties. Bill of pains and penalties. What is a bill of pains and penalties? Bill of pain and penalties. Where is it at? Bill of pains. And now y'all probably wondering why he always go to Black's Law 8th edition. Because when I was in jail, my daddy sent me a Black's Law 8th edition. It is not that I have anything against any other dictionary. That is the dictionary I did all my studying in. A lot of the 10th, the 11th, the 9th, they got very similar. They're very similar to the 8th. The 7th is very similar. 6th, it starts getting kind of different and going off a little bit. The 6th on down. All right. But the 7th, 8th, 9th, 10th, and 11th are all very similar. But it ain't nothing special. Some dictionaries do have better definitions in it. The 4th edition for some words. Bouvier's is going to have 1856. Is going to, when you start studying, when you're doing some deep study, that's why I have all of these dictionaries in here. But I just want to make it known it's not no particular reason. The 8th is just the 8th is, that was just, it's just my favorite dictionary. That's all. But it's not saying it's the best. I'm not saying it's the best by any means. So we're looking for a bill of pain and penalties. Let's see if we can find it. Bill of pain and penalties. Oh, wait a minute, hold on. And go bill. All right, and penalty. That one right there, bill of pain and penalties. Oh man, it didn't take. Hold on. Let's see if I can find it like that. Bill. Oh, spelled it wrong. Okay, let me just see if I can find it like that. Bill. Oh, there it is right there. All right. Bill of pains and penalties. There it go. Bill of pains and penalties, a legislative act. Now, this is a legislative act. You need to look up act, see what that is. That, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. Bills of pains and penalties are included within the U.S. Constitution ban on bills of attainder. All right, particular. Now, I'm gonna break it down for you. What essentially it is you not being brought in a court of law or an Article III court. You're supposed to be in a court of justice, and you're going to get true justice for a private individual from the public. You're supposed to be brought in Article III courts. Article III courts are the defenders of private rights. So a bill of pains and penalties is you taking me into a legislative tribunal without access to a real court of law, which is an Article III court. That's essentially what you're saying. Got it? Good. All right, let's keep going. All right, so when I specially visit your court, notice we're making a special appearance, visit your court on a forced response, all right, of such and such date to a bill of pains and penalties issued by the officer named at the police agency employed by the corporate state of Texas. I move this court and you, Judge, to take judicial notice that my special visitation was forced, that my visitation is special and not general, since this notice is my timely and specific objection to the presumption upon which a false conclusion of law has been made administratively with regard to my status before this court. The plaintiff in this case is an administrative officer representing the corporate and de facto state of Texas, which is legislative power. Notice we keep talking about legislative, Article 1, power to compel performance upon the letter of his statutes upon all persons, not people, persons, subject to his jurisdiction. The only due process that its legislative courts recognize is the right to be heard on the facts of the case. The corporate plaintiff in this criminal action before this court has made an unproven conclusion of law that Yusef is among those persons who have lost or otherwise abandoned their status in the guaranteed Republican form of government and who must perform under legislative power upon the exact letter of every legislative statute with no due process of law protection other than that outlined in paragraph 2 of this letter. It is this false conclusion of law that administrative officer so-and-so issued the contested bills of pains and penalties upon Yusef. This court must take judicial notice that Yusef, an unenfranchised individual. What does unenfranchised mean? Because all of this is coming out of Washington, D.C., and hell, you may never have even been to Washington, D.C. That's why they call it a franchise. That social security number makes you a franchise. It makes you a franchise of Washington. Just like you have a home office, in such a state. Like I think McDonald's, home office in California, and they got franchises all over the world. That's what you are. When you're a U.S. citizen, you are a franchise of the District of Columbia, of the United States. They don't call it U.S. for no reason. They label everything that they own U.S. U.S. Postal Service, U.S. person, U.S. citizen. U.S. District Court. They tell you what it is. Do you know you have a United States District Court and you have a District Court of the United States of America? Go look it up and go research. All right? So right here, what does he say? It is from this false conclusion of law that administrative officer so-and-so issued the contested bills of pains and penalties upon Yusef. This court must take judicial notice that Yusef, an unenfranchised individual, has made a contrary conclusion of law to that of the plaintiff. Yusef claims his guaranteed, fundamental and unalienable rights stemming from both the national and state constitutions to full due process of law and all criminal actions against him means he is subject only to judicial power, not legislative power. This is distinction he's making right here. This is why he's calling it a contested pains and penalties, because you're trying to subject me to legislative power when I, as a private citizen, am supposed to be subjected to judicial power. Said judicial power, when exercised over him, requires a corpus delicti or a damaged party who is sworn out a verified complaint against him. Take notice, all the drug dealers out there. That is called a victimless crime. Ain't nobody sworn out no affidavit against you that you injured somebody. It's talking United States versus you in all caps. If I got a right to face my accuser, how is it the United States against me? The United States is a legal fiction. So you trying to sell me that a legal fiction can go against a real person? Is that what you're trying to tell me, attorney? Is that what you're trying to say? You're not stupid, you sound. Let me read that again. The court must take judicial notice. Somebody said, Joseph G. Major, did you see my 2 Jack Smith classes on my case through email? I got my secure party package. Hope I see you again at Public Respect. Okay, bro. Oh, yeah, I remember you, bro. Okay. All right. I'll check it out. Right here it says, this court must take judicial notice that Yusef, an unenfranchised individual, has made a contrary conclusion of law to that of plaintiff. Yusef claims his guaranteed fundamental and unalienable rights stemming from both the national and state constitutions to full due process of law and all criminal actions against him means he is subject only to judicial power, not legislative power. Said judicial power, when exercised over him, requires a corpus delicti, injured party, or damaged party who is sworn out a verified complaint against him. This is lacking in the criminal complaint against Yusef brought by the plaintiff. So, the unlawfully charged Yusef declares that this unenfranchised status as a preamble American citizen, notice we have citizen with a capital C, all the citizen words before the 14th Amendment are with capital letters, which means a proper noun, and all the citizens you see in the Constitution after the 14th Amendment are in lowercase letters, which is a common noun. This requires you understand grammar to understand the importance that one is a proper noun and a common noun. Common noun can be any goddamn thing. It could be a corporation. So we got this capitalized: American citizen of the guaranteed Republican form of government known as the United States of America, an inhabitant. Notice we ain't say we a resident. We ain't say resident. That's another thing. You need to get American jurisprudence and study the difference between an inhabitant, inhabitancy, and resident and domicile. Domicile, resident, inhabitant, and inhabitancy. They want you to be a resident. I'm doing a video right now on resident. I'm doing it right now by Howard Friedman. They will always call you a resident. Res means thing, identified, a thing that's been identified. All these words are very important. Let's read that again. So the unlawfully charged Yusef declares that this unenfranchised status is a preambled American citizen of the guaranteed Republican form of government known as the United States of America, an inhabitant of Texas, that without a corpus delicti, no court, judicial, or legislative tribunals has a criminal jurisdiction over his person or property. Therefore, the Q specially visits before the law side of this court, seeking its protection from the excess zeal of corporate government, trusting that the court will assume a neutral stance at law and require the corporate plaintiff in this criminal action to prove its in rem or its in personam criminal jurisdiction over the accused to be a fact of law before the court will take on the role of judging the facts of this legislative charge brought before you. Your solemn oath of office compels nothing less from you. And this nigga right here is a beast. I used a lot of stuff out of this in my criminal case, man. But I mixed it up. I pulled all the portions out of it I needed. I was looking at all type of stuff. I used a lot out of this right here. This right here, I was like, damn, this dude right here, he understands. You can learn a lot just studying this damn letter. This letter is a damn course. This letter is a course. This letter exemplifies someone who has full understanding of what is going on. It is the best damn letter I've ever read. Thank you, William James, for the $4.99, brother. $49.99. I appreciate that. Yes. He says, in other words, it is the basic element of a crime that must be established before a defendant can be found guilty. The concept of corpus delicti has two components, the criminal act. Well, what it is that's what an abatement is. An abatement is, hey, procedurally, you're out of order, court. We haven't established this. Before you can continue and presume that you got jurisdiction, okay, because y'all talk about challenging jurisdiction, but procedurally, I'm not going to challenge jurisdiction. I'm just going to challenge the procedures. We need to establish on the record exactly the nature of the action and my status before the court. Because you're presuming that I'm some sort of corporate entity. But do you see that we put in a what? We put in a what? A denial of corporate existence. Why? Because they can do what? They can presume, they have a right to presume what? You're a corporation. Let's read it again. Right here, Louisiana law, revised statute, criminal procedure. This is criminal procedure. Criminal procedure. This one over here in Georgia, this was criminal procedure. This is criminal procedure. On trial of any criminal case. You see this word, any? If you in Louisiana, your ears should be standing up like goddamn Dobermans. On trial of any criminal case, it shall not be necessary to prove the incorporation of any corporation mentioned in the indictment, unless the defendant, before entering upon such trial, shall have filed his affidavit specifically denying the existence of such corporation. Why do you have to deny the existence of a corporation? That should be pretty simple. They listed down in the Secretary of Damn State. All right, so I'm going to show you a couple of other things. Let me show you something real quick. We're going to get back to the Admiralty. All right, but let me show you some other stuff. So I'm reading the Georgia code. Let me go to Justia. All right, Justia have all of the codes for all 50 states. So you go to justia.com right here, and then you got the U.S. states. And so these is all the codes for all the states. So if you looking for your state code, you come right here and find any state code for any state. So I go over here to Georgia, and where are the, well, no, that's not the state codes. Where are the codes at? These are U.S. states. What are the codes? What are the codes? U.S. codes. I'm looking for the code. Legal research, U.S. court, schools, laws, cases, and codes. Is this it? Yeah, here it is. All right, here they go. All right, so Georgia law. Okay. All right, so here go 2022, updated. You want to go to the next? All right, so you see here our commercial code right here is Title 11. And then we got criminal procedure, but right after that, we got debtor and creditor law. Debtor and creditor. So I went in here. I said, well, let me read this real quick. So I go to the general provisions, and it says, creation of relationship. It says, whenever one person by contract or by law is liable and bound to pay another an amount of money, certain or uncertain, the relation of debtor and creditor exists between them. So this right here, if you're telling me this, Georgia, that anytime I owe somebody some money, debtor, creditor, a law applies, and then I go over here to Title 17 under criminal procedure, under 1711(1), and it says that when I'm found guilty of something, that it is a what? What is 1711(1)? OCGA 17. Okay, I might be in the wrong one. Criminal procedure. Yeah, right here. 1711(1). All right, I go over here and it's talking about when I'm found guilty of something, the cost of a prosecution, except the fees of his own witness, shall not be demanded of a defendant until after trial and conviction. If convicted, judgment may, this means must, may means must, be entered against the defendant for all costs accruing in the committing in trial courts and by any officer pending the prosecution. The judgment shall be a lien. This is evidence of a debt. From the date of his arrest on all the property of the defendant. They putting a lien on all my property? So no wonder. So wait a minute. Hold on, man. So what? Wait a minute. So you putting a lien on all my property. You ain't told me this, that I found guilty. I don't even know. The only way I can think of that the government can locate all my property is through my social security number. So when you see we do a secure party process, what we're doing is we're filing a UCC1 and putting a lien against all our property, because how the perfection of liens work, first in line, first in time. So you can't come behind me and put a lien against my property and expect to receive something if I already got a lien against it and have given you advance notice of that fact. That's why we send the notice to the United States Treasury. All right, we put the government, everybody on notice. You got to send them a copy of that UCC1 prior to anything happening. Well, you know, if a judge say we only take cash, check, or credit card, you just simply say to him, am I understanding the honorable judge is willfully violating public policy? Watch what they say. He said, I'm sorry, we only take cash, check, or credit card. I'm sorry, Your Honor, but am I to understand that the honorable judge sitting on the bench is willfully violating public policy by requiring me to pay with cash, check, or credit card? Public policy says you cannot be. Why do you think they don't have it in none of these contracts? You required to pay in a particular species of currency. They say it got to be in lawful money of the United States, but that's why you go read the affidavit of Walker Todd, who's an expert witness. He said ain't no such thing. He said that's an archaic term. There is no money. They only have credit. Federal Reserve notes are worthless pieces of paper. They're evidence of a debt. Debt is used as money. So you saying that's lawful money of the United States? Negotiable instruments are contracts. Where did I get that? Right in the first chapter of American Jurisprudence on the Bills and Notes. Y'all go over there and read it yourself. All right. Let me find one other thing for you real quick. Let me see if I can find this real quick, because I want to show y'all this. shit, I can't get in the damn. I can't get in the damn Dropbox. Let me see. Well, maybe I can. Hold on. Maybe I can. Maybe I can. Let me see if I can pull it up. Let me see if I can pull it up. I think I got court, case log, court. Shoot. If I pull this up for you, something I want to show y'all. Something I want to show you real quick. That wasn't it. I don't know. Let me see. I'm trying to find it. I want to show y'all this law book. I made a copy out of the law library. And the reason I want to show y'all the difference in reading something on the internet and actually going and pulling a book off of the shelf, and the difference between the two. Let's see if this is in here. No. Oh shoot! I keep doing that. And I forgot where I put it. I had to, while I redid this website, I had to move stuff around. I used to have real quick access to all of this stuff. Let me see. Let me try one more search. Yep, I think I found it. Let's see. Is this it? No, that's not it. Georgia Code, man. Shoot. Man, I had to do it tomorrow. I'm gonna show you. I'm gonna tell you what I was gonna show you though, so you can do it yourself. The reason what I was looking for, I'm looking for the book. And man, it's a lot of good stuff in there, boy. Y'all better get on my website. Man, it's a whole, I be forgetting all the stuff that's in here. I'm like, damn, I put a lot of stuff in here, man. There's a lot of stuff in here. I put a lot of stuff. I done collected a whole bunch of stuff over the years. It's crazy. I've been doing a lot of research over the years. A lot of research. I don't see the, but what it is this. I'll tell y'all. That code I just read, OCGA 1711-1, you need to go and pull the book off the shelf and read the case law under it. Then you'll understand why I say may means must, because the judges will break down and tell you what everything means in there. And like, do you know that when you go to jail, the hot dogs and everything, every time you eat, you're being charged for that? That's part of the lien and part of the cost. Them feeding you all, that food is not free that you're eating in jail. That's slop that they are that you are eating. That is a part of the cost that they're putting in that lien against you. You know that? Your clothes. You know that? So I was trying to look for this. It's very interesting when you go and read it because you'll find out some stuff. And dang, man, I wanted to show y'all that. That's let me see if I got it in here real quick. If I got it in here, I got to see if I got it. I got to look in here real quick to see if I got it. Because that, I do want to show y'all that. I want to show y'all that bad. Georgia. I found it. I found it. All right, y'all. Hold on. Let me send it real quick over here and get it on this computer. Let me just get it on this computer real quick. And I'm gonna pull this up. I gotta show y'all what I'm talking about. So I found it on this computer, but I'm gonna transfer it over to the other computer. So just give me a quick second to do that, and I'm gonna show y'all what I'm talking about. This is very interesting. Very, very interesting. Very interesting. And the reason I want it because I want to show y'all the importance of going actually to the law library. To actually go to the law library. Where I originally found all this stuff, you know. That thing act like it don't want to upload. Really? You're gonna pause and freeze right now. I'm trying to do this. Really? All right, hold on. Let me just do it this way right here. Okay, there we go. All right. All right, let me pull it up real quick. I got a new computer, y'all. I got this new damn computer, man. I got to do all this. You ain't break the computer in yet. I don't need to do all that. Just put me in here. I don't need to do all this either. Can we just go, please? Can I go to Gmail and pull this up? All right, here it is right here. So let me pull it up. All right. So I just downloaded this. I emailed it to myself. It's going to download real quick. What it was is I was at Emory University Law Library. I was down in Emory University, and I was researching this. All right, so right here you can see the scan of what I scanned. All right, so right here you're going to see. Oh my goodness gracious! All right, so this is what I just read to you. OCGA 1711-1. All right, this is why you go into the law library, because you want to see how the code is applied in different situations. So right here, judge has no discretion. Right here. See right here, judge has no discretion in the matter of taxing costs. While the word may ordinarily denotes permission and not command, the use of that word in the second sentence of this section cannot be construed to mean that the trial judge is vested with discretion in the matter of taxing the costs against the convicted defendant. Notice they call it a tax too. Notice they call it a tax. There is no provision of law for the payment of the fees of the officers of the court when the judge and the judge's discretion fails to tax the costs against the convicted defendant, and it cannot be assumed that it was ever intended that the compensation of these officers should rest in the discretion of the judges. This is also why you ask for an assessment of the charges. Remember when I said in there, it said, Your Honor, please direct the prosecutor to provide the assessment for the charges along with a certified audit trail of all transactions, including vouchers, as well as all disbursement documents and receipts. because you don't know exactly what they taxing you for. Give me an itemized list of everything that you taxing me for. Because right here it says that you put a lien. I showed this to an attorney. He kicked me out of his office because he was saying commerce don't have anything to do with it. I said, if creditor and debtor law and a UCC don't have nothing to do with it, then why the hell you putting a lien on me? Hell, Article 9 is dealing with this shit right here. Liens. Priority of perfection of liens against property. What you mean the UCC don't have nothing to do with it? So you can put a lien against my property, but I can't. Is that what you're telling me? I thought equality under the law was mandatory. How you, the public servant, can do something to me that I can't do to myself? Let's look at something else. Let's look at something else. Where'd I get this from? Look at something else in here. Something else that was real interesting. Right here. This right here, costs are collectible by a FIFA. This is what Gene Keating, he hit me to this. And I man, when I found this, I gave so much respect to Gene Keating because he talked about FIFAs in there. He said the cost in the criminal prosecution are collectible of the defendant by the levy of a FIFA. FIFA is short for fieri facetious, and it means you have cause to be done. Let's look at FIFA real quick. What the hell is a FIFA? What is a FIFA? Let's look at it real quick. What is a FIFA? Let's go to the dictionaries. They levying a FIFA against you. So what is a FIFA? Let's look at it real quick. And you're going to see this in y'all court documents. Y'all ain't been looking. You ain't been looking. You ain't been paying attention. Your ass just go. It's like fucking McDonald's in the courtroom. Sign here. Say this. Take your ass to jail. Do not pass. Go, nigga. I'll see you in a couple of years on probation. That's what it is, all right? So right here, so let's look at what a FIFA is. All right, so let me go back to my trusty 8. What is it, FIFA? There it is right here. First thing popped up. Fieri facetious. All right, so here it is right here. This is a fieri facetious, Latin, that you caused to be done. You the cause of it. You caused it to be done. A writ of execution that directs a marshal of a sheriff to seize and sell a defendant's property to satisfy a money judgment. What? So, okay, the more, listen, man, let me tell y'all something. The more I study this, it just sounds ridiculous. You got all these people, don't use the secure party process. You got some dudes out there teaching about equity. It is equity related. Equity is the remedy. But for you to sit here and deny, they're talking about the secure party brings you under the, no, it fucking don't. Stop talking about shit you ain't studied, man. Stop talking about because you want to sell some shit that costs $8,000, $6,000, $5,000. I done looked up all and down these statutes. Every time I look at something and turn around, it's commercial. Everywhere I look. Liens, money judgments. Secure party process is putting a lien because you know why they want to put a lien? Because lien is how they create money. That's why they don't want you filing a UCC-1, because they can't create no money off your ass. Because debt is serving as money. So I need evidence of a debt so I can sell it. What do you think these municipal funds are full of? What do you think they do with your car contract when you buy a car? What do you think they do with your mortgage contract? It's called a mortgage-backed security. It's all the same shit. We had a Bloomberg screen and saw that every case in America is being monitored on the goddamn stock market. and has an associated Yusef number attached to it. It's called a FIFE. Okay, so when we go back over here, we go back. It tells you right here, costs are collectible by levy of a FIFE. Cost of a criminal prosecution are collectible of the defendant by the levy of a FIFE at the termination of the prosecution, if it finally results in the conviction of the defendant. Let's get down here and look at something else. Cost of feeding the prisoner. Cost of feeding the prisoner while prisoner is in prison awaiting trial are part of court costs collectible from the defendant. This is where I'm getting at. I ain't making all of this up. This is why I like going to the law library. I'm not making this shit up. You go and you can find it. You be like, okay, what do you mean? They put in a levy. I'm protecting my property. Next we have to decide, what do you mean by when you say property? All right, what is a property? The only thing that they can attach is anything connected to your Social Security, man. They can't attach nothing else. It's the only thing. What else can they use? How else they going to identify your property? If you don't have a Social Security number with the government, how are they going to identify your property? What property do you got? I'm going to wait. Somebody tell me. I'm just saying. I'm just showing you. And this is the stuff I learned many years ago. All right. It's so much more. It is so much more. If the courts are talking about it, but you're going to have to lay the foundation. Once you got an understanding that it's all commercial, then you can move forward with confidence and know, okay, now I understand why I'm doing a secure party process. Not just, I'm just throwing something. Ain't nobody showing you this shit like I'm showing you right now. Ain't nobody showing you this, man. Nobody is showing you this because they haven't done the research. They talking about equity courts and they talking about God and, you know, and all that, you know, they taking you somewhere else on some other shit on a trip somewhere and they ain't explaining things like this, man. They haven't went into these books and just read them, looked up every word, looked up every damn word, read the case, understood the principle behind it and how it applies, how it has a universal application. What time is it, man? I'm not just sitting here talking about this for no reason. I didn't put together a university for no reason. All right. I'm trying to teach you this. I'm not trying to sell you no paperwork, man. I'm not in the business of selling paperwork. That's why all the paperwork is free on the website, man. I got different types of paperwork. I got like 3 or 4 different types of all kinds of different bonds you can use, all types of different security agreements you can use, showing you different ways to fill out your UCC1. I don't give a fuck about none of that shit. You can go through all that and you can figure it out and do whatever you want. I'm not selling you no damn paperwork, man. I'm not selling you any paperwork. I show you step by step how to file your paperwork, how to put it together. You can put it together how you want, but the rest of it is in your court. You got to learn this stuff and understand what is going on because you are battling principalities in high places and they're going to sit there and try to tell you that you're crazy. And if you don't know what you're talking about, you're going to look crazy. They're going to come in and put you on the internet and say, this is some more of that sovereign citizen bullshit. You don't see them putting my shit and doing that. They ain't trying to direct people over here to my channel. That's what this is. You know what I'm saying? Notice our claim of county for fees on the county. It's the claim. We talk about claims. The claim of county for fees on county officers. There's the thing I'm saying. This is why you go in the courtroom. You can try this. Do you have a claim against me? Anybody talk to you? Do you have a claim against me, sir? Do you know anyone who does have a claim against me? I request that the Honorable Judge direct the prosecutor to answer whether there are any more charges. You have to say that so they can't come up with some shit later on. I request that the Honorable Judge direct the prosecutor to provide the assessment for the charges, along with a certified audit trail of all transactions, including voucher, as well as all disbursement documents and receipts. This is why you're doing it. I'm accepting it for value and consideration in exchange for full set-off of all charges levied against my all caps name. Anything. I'm the holder in due course. Here's a third-party intervener making a special appearance as an authorized representative for the defendant. I accept for value, return for value all the charging instruments in this matter, and make my exemption as principal available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts contained in the charging instrument. Please use my exemption for offset and adjustment of the public charges against the defendant and release the order of the court to me immediately. Now you begin to understand what you're saying. I understand why I'm saying I'm the holder in due course. I understand why I'm a third-party intervener under Rule 24, because everything on that piece of paper is a legal fiction, and you're trying to attach my property, and I have an interest in my property. Let's look at it real quick. I am on the phone. I am doing a live stream, dear. Yes. Okay. I'm a third-party intervener, so let's look at that real quick. Where did that come from? Let's look at something real quick. I'm gonna give y'all another little jewel. Yeah, a little jewel. All right. So let's look at Rule 24. All right, Rule 24, intervention. All right, this is what I'm talking about right here. All right, intervention of right on timely motion. The court must permit anyone who intervene who is given an unconditional right to intervene by federal statute or claims an interest relating to the property or transaction that is the subject of the action and is so situated that disposing of the action may, as a practical matter, impair or impede the movement's ability to protect its interests unless existing parties adequately represent that interest. You're not getting adequate representation when you have a public defender. He's not adequately representing the property. You're intervening into it because everything on that paper is a legal fiction. So you're a third-party intervener. I'm coming in. Okay, now I'm going to show you in creditors and their bonds why the verbiage is the way that it is. Let me show you something next. Let me just see if I can just pull it up. Let me see if this is it. Whenever you see this one on the internet, I had somebody do this, and it is a piece of garbage. This dude, it's so many spelling errors and things in here. I want it off the internet. That is not a good PDF version of it. This is the one you want right here. This is the one. That's the one you want. I can't get it out of here. But this is the one you want right here. Let me see if I can get to the end of it. Hold on, I might can, let me see. Yeah, we might be able to see it just on here. Yep, let's see. All right, so right here, there's a letter that goes to your attorney. So in his letter, right here. All right, this is a letter to the attorney right here. So what you're saying in this letter, oh shit, did I fucking, damn, did I hit something? Fuck. right here. It says, please take note that I'm claiming an interest relating to the property which is the subject matter of this action, and I'm so situated that the disposition of the action may as a practical matter impair or impede my ability to protect that interest which is not adequately represented by existing parties. Okay, so now we see where he got that verbiage at. You can use the verbiage as long as you don't quote the statute, because they all operate under the same principle. Notice that he put this in his paperwork, but he did not quote the statute. All right, that's it for today. I think I'm gonna come back tomorrow. We're gonna do some more, but I wanted to impress upon y'all's minds the reason I'm where this stuff comes from. I mean, I can show y'all so much more stuff than this. This is basic stuff to me. It's all basic, just basic information that you can learn. But what you'll start to do is you'll start to see things. I want to show y'all why you see certain paperwork like the affidavit of denial of corporate existence. Somebody found that in Louisiana. And you'll find bits and pieces of evidence of things. And that's why they came up with that affidavit. And it's just prudent for you to put that in there because we're talking about everything in there as a corporation. They can presume that you are a corporation unless you rebut it. Everything operates under presumption, assumption, and color of law unless you rebut it. Okay? And you cannot rebut a presumption with a presumption. You have to rebut a presumption with a fact. So that's why you need an affidavit. It all fit together like a puzzle once you start studying it. I might be wrong. I don't think so. Start studying attachment liens in your state. If you want a place to look in the statute, study attachments, writ of attachments and attachment liens. Start your research there and get into anything creditor and debtor. And then it will lead you into different directions. It would help if you understood admiralty somewhat. I'm gonna get back into the admiralty. The rest of that admiralty, it gets a little bit, I don't think it's really germane. I don't think it'd be wasting time me reading it, trying to explain all that stuff because it's really not germane. We need to get to the second portion that gets into the statutes and the procedures of admiralty, and then into the case law after that. The history is pretty interesting. I only read the history to let you know that in there he tells you that admiralty is not about the locale, it's about the subject matter. The subject matter is commerce, it's commercial, anything commercial. So 90% of commerce goes over the sea, but you have another 10% that goes over land. That is why your vehicles and everything are looked at as, and it tells you even in here, let me show you this right quick. This is why you want to read this right here because, oh man, this right here is so bad. And this book right here, these dudes right here, they got down with their research. I ain't gonna lie. The secret special maritime jurisdiction of the United States exposed. All right, so in here he got the case law where he starts talking about this judge is talking about how the admiralty has expanded. Where is that he was talking about? Let me see if I can find it real quick. Let me see if I can. I want to try to see if I can find. I'm gonna have to read the whole thing to you, but what it is consider it is in here. It got the case law to show you how the admiralty is extended on the land. Is what I want to show you. It's extended on the land. So what they talking about admiralty is just for the sea is some bullshit. That's some bullshit. It says right here how they do it. The process of bringing the harmless tadpole out of the sea and transforming it into a fire-breathing murderous predator on the land began, as near as the author can determine, around 1851, and recognized by the holding of the Supreme Court in the case of Appellate Genesi Chief et al. Versus Fitzhugh. Warning of the power of Congress to expand the admiralty jurisdiction of the federal courts. All right, so the beast of Revelation 13:1 has risen from the sea and come upon the land, and the dragon Congress has given him power, and the power was given to him over all kindreds and tongues and nations. If the reader is still not convinced that the courts are exercising and enforcing a maritime jurisdiction, the following portions of Proctor Wiswall's lecture should help. And he goes, in the United States, the first development noted in the 1966 merger of the old General Admiralty rules into the Federal Rules of Civil Procedure. Though several commentators made predictions concerning the effects of unification upon the substantive law of admiralty, it was not until the late 1970s that the Admiralty Court began to exercise with any measurable regularity the power to administer equitable remedies in admiralty cases. The delay may seem strange, especially in light of the quite rapid effects of the 1938 merger of the equity rules in the first Federal Rules of Civil Procedure. But the late Depression era, the 1933, was one of great social activism of the part of the federal government, and this faded seamlessly into wartime legislation which appropriated control of private property. The district court under the new Federal Rules of Civil Procedure were quickly forced by the volume of litigation into the wholesale application of equitable remedies and actions at law. The 1938 merger of law and equity rules left no loose ends. The procedure is entirely uniform regardless of the nature of the remedy prayed, though of course issuance of an injunction requires at least an ex parte hearing in chambers. The 1966 merger, however, leaves 6 special supplemental admiralty rules appended to the body, and they do. But that's not what I wanted to see. I wanted to show you where he's talking about the highways, case of the United States which touching on the jurisdiction. This thing is bad. He got all the case law in here where they talking about how the admiralty has expanded. Predatory suit was neat. Where is that thing at, man? It's so much case law in here too, as well as in persona only courts, and you can see so much of the Clerks Praxis in here too. After you read it, you'll see so much of the Clerks Praxis in here too. And let's see, the peers assurance. Man, I had to come back and read it. I'm actually doing a video on this. I actually did a video on it. I did 2 videos on it, but I'm doing another one where I'm actually reading this entire document. I'm gonna post it on the internet. But when you read this, I was kind of just, doing a cursory overview of it. But if you read this in there, it tells you how the admiralty is expanded on the land. So don't let them fool you talking about admiralty just has to do with the sea. It is the law of the sea, but it's not about the sea. It's about subject matter, which is commerce that goes over the sea. But they done turned everything into a commercial matter. Everything out here is now commercially related. They have seized jurisdiction. This is how they're going to bring in the New World Order. That social security number. I'm warning you right now. I'm warning you right now. All right, all you socialists out there, all you leftist people out there, all right, because y'all some of the most ignorant people politically that it is. I can't believe it. You have no understanding of how this country was put together or the spirit and intent of the Constitution for the United States of America or what freedom really means. And you're just too concerned with racism and all of this stuff, and it's blinding you to the truth. You don't understand what is going on. You are some of the worst. As a matter of fact, you're a danger. You are a danger of putting us in slavery. You're allowing these people to go out here and convince you they're using that victimhood mentality, okay, and want you to have the government to intervene in your favor, and that's the worst thing that you can do. The United States of America was not built to be we weren't built to be subjects of our government. The government was built to be subjects of us, and we were also supposed to stay out of our business. That's what private property is. Private property is freedom. If we don't have any private property, you don't have any freedom. So basically, if you're the kind of motherfucker that don't believe in freedom for individuals, then I don't know what to say. You are a communist, Marxist, socialist pig. And you're a traitor. You're a traitor. And that goes for everybody in government too. Anybody puts in socialism or communism is a traitor to your country. They're a traitor to freedom. They're a traitor to everything. And that social security number is the mark of the beast. When I teach you what the secure party process was put in place to get you out of the system, but to allow you to operate in the system through another artificial entity, like a corporation, an estate, a trust, or something like that. CPN numbers, all of that. That's what you should be using. You should be creating a fictitious entity to interface with them, not a social security number, because the social security number is evidence that you're an acceptor of benefits and privileges. And we have something called the Ashwander rules. And let me pull this up, the Ashwander rules. Rule number 6. This is what the Supreme Court go off of. Constitutional avoidance. They the protectors. Okay, and they'll tell you they got 6 rules, right? This is what the Supreme Court, they will not take cognizance of a case if it falls under one of these 7 rules. And this one right here, constitutional estoppel. A party cannot challenge a law's constitutionality when he or she enjoys the benefit of such law. You can't, that's what equity does. Equity, you can't come in and start talking about something that's unconstitutional and your ass been accepting benefits and privileges from it. Equity won't allow that to happen. August 5th and 6th, Dallas, Texas. Go to the website. I'll put a link under here. You can register. We reserved some hotel rooms as well. It looks like it's going to be a lot of people there on the 5th and the 6th in Dallas, Texas. Dallas, Texas is a beautiful city. I'm going to show y'all how we party in Dallas on Sunday night. Yes, we are. We're going out Sunday night. Going out to a nice place. I want y'all to pay attention, all right, to what I'm showing you on this. I'm showing you the reason why you're doing all of this. You don't just accept something because people tell you to do it and it just sounds good. You do the research and you start seeing why all these things are in place, you know, and you begin to understand some things of why you're doing it. I'd read this process inside and out. I didn't create it. I didn't create none of this. I didn't create the secure party process, discharging debt. I didn't create none of this. It found me. I just the person, I said I was going to master it. I started studying it for years, and I began to understand how it is applied. And anyone who's been involved in it, you know it's true. They make it very difficult for you. But the reason they make it difficult for you because you don't see all this shit right here, I'm telling you. You got dudes in prison right now. Y'all been studying 20 years. Y'all been studying the wrong shit. Y'all going back and forth to the appellate court, and you studying the wrong shit. You don't understand jurisdiction, bro. I don't care how long you've been into the court, into the law library. You've been studying wrong shit, man. That's why you can't get out. You got to start addressing your status and how the fraud was conducted against you. That's why I be telling everybody about One Man Out. Because that man, he did a lot of damn research. You got to basically document the fraud that's been conducted against you. You got to be able to do that first, and you got to do it thoroughly. Thoroughly. You can't just say some shit. Oh, well, the Social Security number. You can't just say some shit out of your mouth. You got to be doing what I'm doing right now. Once you can do that, now we can talk about a habeas corpus. I did stay on topic. What you talking about? I need a co-host to stay on topic. I'm talking about admiralty. I just gave y'all some jewels. This is all on topic. This is all about admiralty jurisdiction. I didn't stay in the clerk's praxis, and I wanted to do that affidavit, but I'll do it tomorrow. I'll do the affidavit tomorrow. I'll set everything up. I should have set everything up and been prepared to do it, but I got a new computer over here, and you don't have a lot of stuff. I had to put Word on here. Now Word coming up, and I have a lot of programs I ain't installed on here. I got 2 computers, so the computer that's showing you everything is my new computer, and I don't have anything. I got all my stuff on this computer, but you can't see this computer screen. So I got a new computer, but it doesn't have anything on it. So, it's still blank. So I got to put stuff on it, and then I can show y'all everything I'm showing you, but I think I did all right today. What do you think? All right. Anyway, I want to thank everybody for the donations, man. I appreciate the donations. I always do. Remember, once again, Dallas, Texas, we're going to get to it. And I see you at SBC University. Once again, if you're having trouble with your account, remember, if you can't find your account, push existing member, put in your information. We'll take care of it. We've been taking care of everybody. All right, so don't, some of you might have slipped through the cracks, but we get into you. Just keep reminding me, post something on the internet. If you want to leave something on the note section on the website saying, hey, look, man, it's been past 24 hours. I still don't have no access. That's fine. We have a phone number that you can call also. We have a number you can call. Somebody answers it. We'll help you, all right? Customer service is a big pet peeve of mine right now, so I'm trying to get some good customer service. Y'all can contact me because I want everyone to have access to this information, and I want you to understand what is going on in the judicial system in the world today and what is at stake by you remaining in ignorance. As Thomas Jefferson said, those who hope to be both ignorant and free are hoping for something that never has been and never will be. Peace to the gods. I'll see y'all tomorrow. Peace. I'm out.